Now, what is the significance of this ruling for AAMA and CMA's AAMA? Well, first of all, in certain states, I was getting calls from CMA's AAMA indicating that their jobs were being threatened because their employers were telling them if CMS does not allow them to enter medication orders, they're not going to continue to hire them. They're going to hire licensed healthcare professionals. This was especially problematic in the states of Iowa, Wisconsin, South Dakota, to a lesser extent, Minnesota and Illinois. I'm just wondering if I could take a show of hands, including the gallery. How many of you were aware of this decision beforehand and were hearing threats? Okay, I think this is a little bit broader than just the upper Midwest, Georgia, Arizona. Well, again, I think this was going to spread. The only reason why it was a problem in the upper Midwest, I believe, was because it was just publicized more frequently and intensely. But now, if you get questions about this, take them to our website, to the article that I wrote, which is in front of you, and you can actually quote the precise language from CMS. You don't have to quote secondhand sources. You can point to this specific language. Now, another question that has come up is, when is this in effect? Some have misinterpreted the language of the rule and have said that it doesn't go into effect until 2013. My best interpretation is that this new ruling of CMS goes into effect immediately. There's some language that might imply that it goes into effect 60 days after the official publication, September 4th. However, I don't think that's the best understanding. I believe that this goes into effect immediately. Another positive point that we need to talk about is that credentialed medical assistants are now officially recognized in federal law, and this is a powerful precedent. Some of you have encountered problems in your state because there is no specific mention of the two words medical assistant in any state statutes or regulations. Your rejoinder to that is to say that, well, the federal government has officially recognized medical assistants, indeed credentialed medical assistants, in the regulations. Now, the CMS rules are just as much the law as an act of Congress. So please keep that in mind if you get questions as to recognition for medical assistants or credentialed medical assistants. Another important part of this ruling, and this is spelled out in my article, is that credentialed medical assistants are differentiated from all other medical assistants. CMS did not say that all medical assistants could enter orders into the computerized provider order entry system. They specifically state that only credentialed medical assistants are going to be able to do that. So really, if you think about this, this is a federal endorsement of credentialed medical assistants. I think that's very popular in the states in which, or very significant in states in which there are right to practice issues. Another point is that CMS actually came out and said that credentialed medical assistants are just as capable as licensed healthcare professionals to enter orders into the CPOE. I know some of you have run into the comments that, well, medical assistants are not licensed, you're just certified. That's not as good. That's a second-class status to licensure. Now you have a rebuttal to that. You can say that the Centers for Medicare and Medicaid Services have said that credentialed medical assistants are on a par in terms of being able to enter orders. So I think that is a very significant point. Just a digression, I know some of you have also encountered criticisms about medical assistants and the CMA AAMA program because they will say that, well, only licensed allied health professionals are subject to disciplinary measures. Please point out quickly and take people to our website that the certifying board of the AAMA has established disciplinary standards. and they are enforced. So there is no difference in that regard. It's not correct to say that licensed people are accountable and CMAs, AAMA are not. We clearly have a disciplinary mechanism and it is enforced, so keep that in mind. Another key point is that sometimes medical assistant has been thought of as a generic catch-all phrase. However, the significance of this regulation is that CMS has said that the phrase credentialed healthcare professionals is the phrase that is overly broad. They have said that the phrase credentialed medical assistants is more precise, and they went out of their way to say that the terms credentialed medical assistant are a more precise and accurate descriptor of the people who should be able to enter orders into the CPOE. Another point in the rule is that credentialed medical assistants are expected to use judgment, and you can read that in the article. There's a long quote from CMS indicating that just not anyone can enter orders into the electronic health record. Rather, only credentialed medical assistants, in effect, can be trusted to do that, according to CMS. CMS also says that laypersons are not qualified to do so. So think about this for a moment. In effect, CMS is saying that non-credentialed medical assistants are in effect at a level of laypersons, but credentialed medical assistants are on the level of licensed healthcare professionals, not secondary to them at all. So again, we see all of these points combining to really strengthen credentialed medical assistants and the CMA, AAMA. Now, the final rule of CMS states that the credentials that they're talking about for medical assistants must be given by an independent testing or credentialing body, such as the certifying board of the AAMA, of course. And CMS also says that in-house credentials are not accepted. I was very pleased to see that, and that is very significant. Some of you have been hearing that the wave of the future is that large health systems will develop their own medical assistant training classes and give their own credentials, their own certifications. And I think that is happening to some extent. But if you run into that situation, you can say that CMS has said that those in-house credentials are not accepted for purposes of the EHR incentive program. So that is very significant. Show of hands again, how many of you have had any contact or are aware of these in-house credentials or in-house training programs? Yes, that's a fairly extensive number, again, a broad geographic spectrum. I see that as a very great threat to the medical assisting profession, and this is one way to counteract that. To quote the federal government in saying that in-house credentials are not acceptable for medical assistants in regard to who can enter orders. Also, the logical result is that this rule will strengthen psychometrically sound credentials such as the CMA, AAMA. In my mind, there's no question about that. One question that has been raised is why didn't CMS recognize the CMA, AAMA only? And there are some reasons for that. First of all, professional regulation of any profession is primarily a state matter. Keep in mind that the United States Congress has limited lawmaking authority granted under Article 1 of the United States Constitution. There are enumerated powers given to Congress in terms of what they can legislate and what they cannot. Another source of this is the 10th Amendment of the United States Constitution, which says that powers not specifically given to Congress are reserved to the states or to the people. As a result, Congress does not have carte blanche to legislate in any area that they desire. Finally, CMS did not have congressional authority to evaluate credentials. That was beyond the scope of what Congress gave to CMS. And finally, the Supreme Court decision on the Patient Protection and Affordable Care Act did state that the authority of Congress is quite limited. I just want to read some of this from the Supreme Court opinion, just to give you an idea of the force of law behind this. And this is the majority opinion. The federal government has expanded dramatically over the past 2 centuries, but it still must show that a constitutional grant of power authorizes each of its actions. The same does not apply to the states because the Constitution is not the source of their power. States are sovereign governments that existed before the United States of America, as we know. The states thus can and do perform many of the vital functions of modern government, punishing street crime, running public schools, and zoning property for development, to name but a few, even though the Constitution's text does not authorize any government to do so. Our cases refer to this general power of governing as the police power. Finally, this case concerns 2 powers that the Constitution does grant the federal government, but which must be read carefully to avoid creating a general federal authority akin to the police power. So the bottom line is that Congress does not have the authority to legislate anything that it wants to. It has to find the source of authority in the Constitution, and of course that was all the debate whether the Commerce Clause covered this and allowed Congress to regulate, and of course the decision was that the taxing power given to Congress by Article 1 was sufficient. Again, I'm going to ask you for questions or comments in a minute, but just to wrap it up, I think that it's very important that we seize upon this opportunity. We want to publicize this as widely and as often as possible. Again, we're going to put things that I write on the website. If this turns out all right, perhaps it can also be on the website, this video, as was my presentation last year. And as you see in this final slide, for more information, go to Legal Eye, my blog, and our website. You can have anyone call me at 800-228-2262 or AAMA. And of course, I can receive emails, and I'm happy to respond as promptly as possible to any of those emails. This also has membership ramifications, needless to say. The question, what is AAMA doing for me? This is probably one of the most tangible, significant benefits that the AAMA has provided for many years. Now, there were other comments submitted. In fact, there were 6,000 comments submitted to CMS, not all about this issue, of course, but that just shows you how important this program is. The American Medical Technologists did submit comments, but I think I can say with confidence that the AAMA was clearly the leader in this initiative to change the language in the CMS regulations.